to have with us good evening, ladies and gentlemen. It is my pleasure tonight to moderate this Wednesday one session of the Chartered Institute of Arbitrators, the Egypt branch, hosted by the Cairo Regional Center for International Commercial Arbitration, and to have with me a very distinguished guest, Professor Dr. Yannick Radi, who is a professor of international law at the University of Louvain and member of the exit panel of arbitrators. And he will shed light on his very recent significant publication, which is his new book on rules and practices of international investment law and arbitration. So it's a textbook presentation and discussion that we are going to have today. Professor Radi will speak for about 35-40 minutes, and then there will be a room for questions and answers through the Q&A mean, and not through the chat. So through the Q&A and not through the chat. So just to say something about this textbook, so it deals with the salient features of international investment law and arbitration, and you will see that this book balances between private interest and public interest, because what is at stake here is the interest of the investor and also the interest of the host state of the investment. Also, he will address the reform of the ISDS regime, the investor state dispute settlement, and the alternatives to investment arbitration that are proposed by certain stakeholders. Professor Radi, as I have mentioned, is a professor at the University of Louvain in Belgium, and he is a member of the exit panel of arbitrators. He is also a guest professor of international investment arbitration at Sciences Po University or Sciences Po Law School at Paris. Centre University, it's a grande école, so it's a law school in Paris, and he is an invited professor at the Hague Academy of International Law. It's a very prestigious academy where only notable professors or practitioners are invited to intervene in the courses of the Hague Academy. For those who do not know well the Hague Academy of International Law, it's a very selective academy. And it selects in its summer course every year a very distinguished professor. He is admitted to practice law in France, Professor Radi, and he is also an expert for a state delegation at the legal subcommittee of the UN Committee on the Peaceful Uses of Outer Space, and he participates to the work of the UN Working Group on Space Resources. He is also a member of the ICC Institute of World Business Law, where he focuses in particular on compliance matters. And he has specific expertise and interest in state responsibility and the law of treaties, international arbitration and international investment law, sustainable development, as well as climate change, which are all subjects that are dealt with under the umbrella of public international law. After this presentation, I am happy to give the floor to Professor Yannick Radi so that he starts his presentation. You have the floor.
Thank you very much, Dr. Selim, for this introduction and for the invitation. I am very, very pleased to deliver this lecture. I only regret that I'm not in Cairo, and I very much look forward to being back in Egypt and in the region. International investment law is becoming more and more complex. This is a challenge for foreign investors in the planning, in the conduct of their investment operation. And this is a challenge for host states when they adopt new regulations or when they intend to change existing ones. So I have written this textbook that you mentioned, Dr. Selim, to help states, investors, practitioners more generally, to make sense of this complexity and to have a comprehensive and a detailed knowledge of the rules and practices of international investment law and arbitration. Focusing on both treaty practice and arbitral practice, it covers all the rules which protect foreign investors, as well as those rules which protect public interest. It also analyzes arbitral proceeding and issues like provisional measures, jurisdiction, compensation, or annulment. So obviously today, I cannot present all these issues, which I analyze in my textbook. If you are interested in discussing any aspect, please do not hesitate to contact me by email or LinkedIn. I will be very pleased to have a Zoom meeting with you to discuss that. You will find my email address in the last slide of the PowerPoint presentation. So today, I would like to shed light, emphasize the diversification that characterizes recent treaty practice and focus on the practical consequences that key features of recently adopted treaties have for both foreign investors and host states. To do so, I will first introduce the societal and the policy background which has led to the evolution and to the diversification of international investment law and arbitration. Then I will focus on key aspects of this evolution with regards to both substantive law and dispute settlement, stressing specific practical consequences for foreign investors and states. So let's start with the societal and the policy background. Well, as we know, international investment law, ISDS, are under fire worldwide. From an historical point of view, the fact that international investment law and arbitration is criticized all around the world is quite interesting. Why? Because no doubt international investment law has been challenged in some regions, for instance, in South America, for a very long time, but it used to be strongly supported in other regions, like in Europe. But as you know, even now in countries like Europe, international investment law, ISDS, is also very much challenged. So all around the globe, the criticisms are mainly twofold. They concern two issues which are connected, which are the right of states to regulate and ISDS. So I will say a few introductory remarks about the criticisms pertaining to those two issues, starting with the right of states to regulate. So what are those criticisms? In a nutshell, treaty provision, as they have been applied by some arbitral tribunals, for instance, expropriation, are considered by many as preventing states to regulate, protect public interests like public health. Why such a chilling effect? Well, because those provisions are seen as constituting kind of swords of Damocles, if I may say, states preferring not to adopt or not to change a regulation because they fear that arbitral proceedings may be initiated and that they may have to pay heavy compensation. So as you can see, with regard to this chilling effect, ISDS plays a role. But this is actually not the only criticism addressed against it. ISDS is seen by many as not being fit for purpose because of the public interest, which is often at end in investor-state arbitration and which has become central over the past decades. It has become central in the 90s, in particular as a result of the possibility offered to foreign investors to initiate arbitral proceedings on the basis of treaties and not merely on that of contracts. This is a consequence in particular of the AAPL versus Sri Lanka case. So why is ISDS not seen for purpose? Well, because of its traditional feature like confidentiality, its ad hoc nature, and the consequences of this in particular in terms of coherence, because of the choice of the arbitrators by the disputing parties. But more fundamentally, ISDS and arbitrators are seen as lacking the legitimacy to settle disputes in which public interest is often at stake. So what have been the consequences, the implications of those criticisms? Well, this has led states and international organizations to initiate a global and an inclusive brainstorming on both substantive law and dispute settlement, which has already led to an evolution of treaty practice, which will continue in the years to come. At the core of this evolution, there is first the issue of the balance to be struck between public interest and private interest. And second issue, the determination of the best dispute settlement mechanism to settle investor-state disputes. So no doubt there is a consensus in favor of ensuring a greater protection to public interest and of reforming the settlement of investor-state disputes. But beyond that consensus, treaty practice displays a diversity that actually reflects the different policy choices made by states when striking a balance between public interest and private interest. This is what I will now analyze by focusing on the text of some relevant treaties. So I will first shed light on the diversity displayed by treaty practice in relation to substantive law before turning to the various options implemented or discussed to reform the settlement of investor-state dispute. So let's start with substantive law. So we are all very much familiar with the diversity that characterizes arbitral practice. Think, for instance, about the decision, award, dissenting opinions on the application of the most favored nation clause to dispute settlement. So I will only refer to the case law incidentally to support my analysis. But I'm happy, obviously, to discuss it during.
Perhaps you may wish to explain this issue because perhaps some of our audience would not be aware of this very technical aspect.
You mean the MFN?
The MFN in general and the issue of extending the MFN to the dispute resolution.
Well, so in a nutshell, a number of international investment agreements, for instance, provide for a requirement to kind of exhaust local remedies during a certain period of time, typically 3 months to 18 months, while other treaties do not. This to avoid exhausting those local remedies, some foreign investors have relied on the most favored nation clause in what is called the basic treaty to ask for an extension of what they considered as a more favorable treatment provided in a third treaty. So this as the first case, or one of the first cases, was the Maffedini case, when the issue was discussed. And since then, there have been disagreements between arbitral tribunals. Some tribunals considering that as a matter of principle, the MFN clause cannot be used to apply to dispute settlement mechanism. Other tribunals considering that the MFN cannot be used for that purpose. So this is very likely the issue which has been the most sensitive one, and which explain why actually this is on this very issue that arbitrators have dissented the most. So most of this is the issue where you find the greatest number of dissenting opinions.
And contradictory awards, I believe, as well.
Yeah, contradictory awards, and then even
within the same award, a lot of dissenting opinions.
Yeah, even within the same tribunal, disagreements between arbitrators, which has led actually the arbitrator who disagreed with the majority of the tribunal to dissent on the matter. So this is just an example of disagreements. As we will see in relation to indirect expropriation and legitimate expectations, there are also disagreements between tribunals on those matters. So disagreements and diversity in arbitral practice, this is something which has been heavily discussed. But what, in my view, is more noticeable in the past years is the diversification that characterizes treaty practice. So to be clear, international investment agreement, be they bilateral investment treaties or free trade agreements which contained an investment chapter, have never been identical. Yet they shared common key provisions conferring, all things being equal, a similar protection to foreign investors. This is partly due to the fact that the bilateral investment treaty models, which, as you know, are used to negotiate most of the treaties which are currently into force, are themselves based on a unique instrument, which is the Draft Convention on the Protection of Foreign Property, which was negotiated in the 1960s at the OECD. So, as I have explained earlier, the different balances struck between public interest and private interest largely explain this diversification of treaty practice. So those balances are really key and fundamental as they determine the scope and the degree of the protection conferred to foreign investors, and conversely, to the protection of public interest. So to illustrate this, I will focus on the two provisions which are the most relevant with regard to the right of states to regulate, meaning the fair and equitable treatment provision, and more specifically, I will focus on the legitimate expectations, and the expropriation provision. And here I will focus in particular on indirect expropriation. So let's focus first on the fair and equitable treatment that I will refer to as the FET. So I will first provide some background elements to help for a better understanding of recent treaty practice. So traditionally, bilateral investment treaties have provided for FET provision, which were very broadly formulated, placing an obligation upon states to accord a fair and an equitable treatment to the investors of the other party to the treaty. Fair, equitable, as you can see, this is very vague. This vagueness has required from arbitral tribunals to specify the type and the scope of the protection that the FET provision confers to foreign investors. So this is in this context that has emerged in arbitral practice the notion of legitimate expectations, a notion which is, for instance, nowadays central in the numerous renewable energy cases faced by Spain in particular. So in a nutshell, the legitimate expectation, what's that? Well, a number of arbitral tribunals have considered that the breach of foreign investors' expectations can, in itself, or in combination with other elements, amount to a breach of the FET. So without entering too much into the details here, two main approaches have been adopted in arbitral practice with regard to the legitimate expectation. The first one was famously stated by the tribunal in TechMed versus Mexico, which explained that foreign investors shall now beforehand any and all rules and regulations that will govern their investment. Such an approach has been seen as turning the FET provision into a stabilization clause, a clause that you are familiar with in contracts. So this approach has been criticized as it can be seen as freezing the exercise by states of their regulatory power and thereby as constituting a threat for the right of state to regulate. On the opposite, the second mainstream approach adopt an approach which is much more protective of public interest and of the right of states to regulate, in the sense that legitimate expectations are based on specific representations and commitments given by the host state to an investor. So this is only when a specific representation, a specific commitment was given to an investor by the host state that there can be a breach of the FET in case those representations, those commitments have been violated. So in light of this background, let's turn to recent treaty practice and compare treaties recently adopted, which, as you will see, display important nuances and differences. On purpose here, I did not include in the discussion those treaty provisions which link the FET provision to customary international law, because it begs the specific question of whether or not the legitimate expectations are part of customary international law. So I will now share my screen with you so that you can have a look at the provisions I'm talking about. So let's start with the Uzbekistan Korea VIT, which actually illustrates those treaties which adopt the traditional approach, the classical approach I had mentioned earlier, by referring merely and broadly to the fair and equitable treatment without providing any further specification. So such a drafting leaves a large discretion to arbitral tribunals, which may therefore adopt either approach I have mentioned earlier, meaning equating the FET provision to a treaty stabilization clause, or limiting the basis of legitimate expectations to specific representations or commitments. Likewise, under such a provision, tribunals are free to consider that a breach of the legitimate expectation in itself constitutes a breach of the FET provision, or to the contrary, that it is not sufficient to have this effect on its own. Another set of treaties are more specific with regards to the basis and or the role of legitimate expectation. So we can take the example of CETA, Article 8.10.4. As you can see here, the CETA limit the basis of legitimate expectation to specific representation and commitment. So that's for the basis. As for the role, it makes it clear that this is only an element which may be taken into account. So a limitation of the scope of the basis of legitimate expectation. Some treaties are more radical with regard to legitimate expectation in the sense that they exclude the legitimate expectation from the scope of the treaty protection. Such a result is achieved in particular by providing a list of the protection conferred to the investors. So here you can see that list, legitimate expectations are not covered. This is an exhaustive list and not an illustrative one. So legitimate expectations are excluded. So you can see first treaty, broad provision, room for tribunals to adopt either approach. That provision, legitimate expectations excluded. Obviously, along this sliding scale, this is the degree, the nature of the protection conferred to foreign investors, which vary. And this has concrete, practical consequences for investors and the protection that they can expect. Conversely, this has an impact on the freedom that states enjoy in the exercise of their normative power. So another illustration of the diversification of substantive law, indirect expropriation. So here again, some background elements. So international investment agreements, again, BITs or FTAs, have merely referred in the text of the treaty to indirect expropriation, measures tantamount to expropriation, measures equivalent to expropriation, or measures having an effect equivalent to expropriation. Such a formulation, such a drafting, has begged the question of how to identify instances of indirect expropriation, and more specifically, it has begged the question of the relationship between indirect expropriation and regulatory measures. What is a regulatory measure? This is a non-discriminatory measure which pursues a public interest objective and which is adopted in the respect of due process. What is at stake in this distinction is the obligation for the host state to compensate the investor. In case a measure is viewed as an indirect expropriation, for that indirect expropriation to be legal, compensation must be paid. So to make this distinction between indirect expropriation and regulatory measure, arbitral tribunals have adopted two main approaches. The one which is best protective of the right of states to regulate was famously referred to by the tribunal in Metanex versus United States. Under this approach, and excluding the specific issue of specific commitments, regulatory measures, as I have just defined them, are never considered as expropriatory measure, and therefore compensation is never due to the investor, whatever the impact of the measure on the investment. A number of tribunals have adopted a more nuanced approach as it is illustrated in Philip Morris versus Uruguay. More nuanced in the sense that they consider that as a matter of principle, regulatory measures are not indirect expropriation, but that such regulatory measures can be characterized as an indirect expropriation if they have an impact which is too severe on the investment in light of the purpose of the measure. In case the impact is too severe, then this is an indirect expropriation, and then compensation is due to the investor. So in light of this background, let's turn to treaty practice. So here again, I will focus on treaties to illustrate trends in recent arbitral practice, which, as you will see, have important consequences for foreign investors in particular. So I will again share my screen with you for that purpose. So first treaty to illustrate that, the Hungary-Tajikistan BIT. So this treaty adopts the traditional approach, referring merely to measures having an effect equivalent to nationalization or expropriation. Such an approach leaves a great discretion to arbitral tribunals to make or not a distinction between indirect expropriation and regulatory measures, and also to decide on the criteria to be used to distinguish between regulatory measures and indirect expropriation. A number of treaties are yet more specific, but specific in different ways. So let's start, for instance, with the Korea Republics of Central America agreement and focus on its Annex 9. Under this approach, regulatory measures, as a matter of principle, are not indirect expropriation, but there is an exception to that principle. The exception being that if the measure is extremely severe or disproportionate in light of its purpose or effect, that regulatory measure is to be characterized as an indirect expropriation, and therefore compensation is due to the investor. Another set of treaties provide for the same principle, but they do not provide for the same exception. And this is illustrated by the Belarus-India BIT. So under this approach, regulatory measures are never to be characterized as an indirect expropriation. Compensation is never due, whatever the impact on the investment. So you can see that already there is an important difference between all these treaties and very concrete practical consequences for foreign investors. In a way, this approach that you find illustrated in the Belarus-India BIT can be linked to those treaties concluded in particular recently by Brazil, which simply and radically exclude indirect expropriation from the scope of the treaty. Under those treaties, so like the Brazil-Suriname treaty, only direct expropriation is covered. Foreign investors are only covered against instances of direct expropriation and not against instances of indirect expropriation. Needless to say that, again, this has serious consequences and for foreign investors. And all these differences that we have seen, conversely, have an impact on the freedom that states have in the exercise of their right to regulate. So important differences and nuances with regard to substantive law. Now let's discuss the differences with regard to the reform of the settlement of investor-state disputes. So you may be already familiar with the work which is conducted at UNCITRAL by Working Group 3. So it started a couple of years ago. Different options, different mechanisms are being discussed. It will take, again, a couple of years before the working group complete its work. However, reform initiatives by states and international organizations have already materialized. Those reforms have followed two main paths. First one, a reform from within, so to say, meaning a reform of investor-state arbitration. Second path, more radically, initiatives aiming to replace investor-state arbitration with another mechanism, or at least to combine it with another mechanism. So I will mainly focus on that second path, stressing the practical consequences of each option. But before that, I will say a few words about the reform from within, how investor-state arbitration is being reformed to address criticisms which have been formulated against it. So very likely, the main criticism formulated against investor-state arbitration is confidentiality and the lack of transparency. As you know, traditionally, documents, decisions, awards were not made public, hearings took place beyond closed doors, third parties had no opportunity to attend or to contribute to the proceedings. So that's the issue which have been the main focus of the initiative by states and international organizations. And here we can emphasize the key role played by ICSID to reform investor-state arbitration. It has initiated reform as early as 2000, which led to an amendment which entered into force in 2006. For instance, amicus curiae were introduced at that time. This effort was renewed in the past year, which has led in the past weeks actually to a new amendment of the ICSID rules of arbitration. Also, to be mentioned, the role played by UNCITRAL with the adoption of the UNCITRAL rules on transparency in treaty-based investor-state arbitration. So now let's move to the more radical approaches to replace, to combine, to address the criticism. So three main approaches. The first one, which is promoted by the EU in particular, and which has already been implemented, for instance, in the CETA, consists in replacing investor-state arbitration with a standing court, consisting in a first instance tribunal and an appeal tribunal. Worth noticing that at UNCITRAL Working Group 3, the opportunity to establish a multilateral standing court is being discussed, which would then have jurisdiction over several treaties. So, be it a bilateral investment court or a multilateral investment court, the legal issues which arise are numerous, and they display very remarkable features if you compare it to investor-state arbitration. But here, I would just like to draw your attention to the fact that with a court, disputing parties would not have the opportunity to appoint an adjudicator. You can see the practical impact of this procedural evolution for foreign investors in particular. a permanent court. Second approach, which is mainly supported by Brazil, has even more serious consequences for foreign investors. Indeed, in the treaties that this country has recently adopted, foreign investors are simply not parties to the disputes, and they are largely excluded from the participation to the proceedings. Why? Because investor-state arbitration in those treaties is replaced with interstate arbitration. Also, investors have no word to say in the decision whether or not to initiate proceedings. So this may make you think of diplomatic protection, a mechanism which turns disputes between a host state and the national of another state to a dispute between the host state and the state of nationality. And actually, you're right. This is quite close what you find in those treaties and what diplomatic protection is all about. But it's here, again, from an historical point of view, it's interesting to remark that we are back to the future in the sense that investor-state arbitration has developed, in particular, as a substitute to diplomatic protection, which was seen as being unsatisfactory for foreign investors because of the politicization of the settlement of the dispute that diplomatic protection entails. Third approach. The third approach consists in conferring a greater role to domestic courts. Here again, from an historical point of view, it is worth noticing that we are back to the future with such an approach. Why? Because also investor-state arbitration has developed as a way to delocalize the settlement of investor-state disputes outside host states. So back to the future again. So this approach to conferring a greater role to domestic courts leads today typically to require a strong exhaustion of local remedies before arbitral proceedings can be initiated. So as I have mentioned a bit earlier when answering your questions, Dr. Selim, in existing treaties, such a requirement exists in some treaties. But the period of time is very short, typically between 3 months to 18 months, depending on the treaty. In those treaties which have been recently adopted, the period is much longer. We speak of years. And in some treaties, there is simply no time limit. So this is a full exhaustion of local remedies. You find an illustration of this in the Morocco-Nigeria BIT. So the rationale for such an approach is clear, and actually it addresses a key concern expressed against the critique, expressed by the critics of investor-state arbitration. In their view, disputes in which domestic public interests are at hand shall be settled first and foremost by domestic courts. At the same time, you also see the practical consequences of such an approach for foreign investors in terms of time and in terms of cost. All things are being equal, such practical consequences also derive from the idea of combining investor-state arbitration with an appellate mechanism. So to conclude on the reform of the settlement of investor-state disputes and to conclude this presentation more generally, I would like to stress a systemic practical consequence that the reform may have, meaning a revival of contract-based arbitration. Well, in international investment law, since AAPL, since the 90s, most disputes have been treaty-based disputes. But nowadays, faced with the limitations to access treaty-based arbitration, and a fortiori, faced with the lack of possibility to access arbitration at all, foreign investors and practitioners will likely consider contract-based arbitration as the solution to continue to have an access to arbitration, which they see as the best dispute settlement mechanism to settle the disputes that they have with their host states. So I will stop here. Thank you very much for your attention. I'm happy now to answer any question that you may have. The floor is yours, Dr. Selim.
Thank you very much, Dr. Yannick, Professor Yannick, for this very interesting presentation of a hot topic, we have to say, that might change how investment arbitration or how investor-state disputes are going to be settled in the near future. Before I ask you a question, I will start with a question asked by Ms. Lilia Klochenko, and then I will ask you a question, and I also invite the participants to ask questions, but through the Q&A window and not through the chat window, please. So Ms. Lilia Klochenko is asking you, so she's thanking you for today's presentation, and her question relates to the arbitral awards in the investor-state disputes that are not rendered by majority, not rendered unanimously, but rendered by majority and accompanied by dissenting opinions, 2 or more. So what's the prospects of enforcement of such awards if such dissenting opinions concern the same aspect of dispute or 2 or more different issues of the dispute? And she is precising, or she is mentioning later that she's talking to some extent about multi-contracts and multi-party disputes. Do you think dissenting opinions would compromise or reduce the prospects of enforceability of arbitral awards? Or the question doesn't distinguish between exit arbitration and other type of institutional investment arbitration?
Right. Well, with regard to dissenting opinion, I don't think that the main issue is a legal one, typically in terms of enforcement. I think that the main issue is in terms of legitimacy, in the sense that dissenting opinions have been criticized for undermining the integrity of the tribunals and kind of the persuasiveness of the reasoning of the tribunal in the award. So in a way, that's why in some countries there is simply no possibility at all for judges who disagree to attach their dissenting views, because this is seen as undermining the legitimacy, the persuasiveness of the tribunal reasoning. At the same time, it can be said that this is an element which participates to increase the transparency of the settlement of the disputes by enabling all the views to be shared with the audience, and this participates in a way to the making of international investment law, in the sense that, for instance, we discussed earlier, Dr. Selim, the MFN and dissenting opinions. If you look at dissenting opinions attached by Brigitte Stern, Laurence Boisson de Chazour, Marcelo Cohen, for instance, they really develop a great argumentation which contributes to the debate, the discussion, this exchange of views, having potentially, it has potentially have the impact of ensuring views to become closer across arbitral in arbitral practice. So I think that really the main issues with dissenting opinions are issues of legitimacy instead of legal issues.
Thank you, Professor Radi. Another question from Mr. Aboubakar Fall from Senegal. What are your thoughts about the new Pan-African Investment Code adopted by the African Union aimed at introducing an African approach to international investment law?
An African approach. Well, taking one step back, I must say I'm not convinced that today there are clearly defined regional approaches. I mean, a couple of decades ago, there was clearly an opposition of approaches between what is called the North and what is called the South. Nowadays, I think that state policies display diversity across Africa as they display diversity across the North, again, between brackets. Africa, yes, if you compare treaties concluded, for instance, if you take the Nigeria-Morocco BIT, it is quite a revolution in the sense that this treaty is very, very much protective of public interest and of the right of states to regulate. At the same time, other treaties concluded or adopted by African countries adopt an approach which is quite traditional and which do not confer such an innovative protection to the right of states to regulate or to public interest. So I am not convinced that there is such a thing as a very homogeneous African approach if you look at the treaties which have recently been adopted by African countries. And here, I think it's also important to note that because you could say that, well, African countries, they have a certain approach when they conclude treaties with other African countries, while the approach is different when they conclude a treaty with Europe, with a country from the North. Well, actually, this is not true in the sense that even when they conclude treaties between themselves, African countries, or even countries from the South, the policy choices which are made actually quite reflect the approach which was adopted decades ago when the treaties were only concluded between countries from the North and countries from the South.
Thank you very much, Professor Radi, for this question. Another question from Mr. Nitin Kumar from India, and apology if I don't pronounce your name correctly. He's asking you about the position in India and because he understands that you have a chapter on India in your book, you have not discussed with regard to chapter in India. So did you deal with India in your book? I'm not aware of this.
Me neither, I must say. No, I haven't. Actually, there is no chapter on specific region. I analyzed a treaty practice in a cross-cutting manner without focusing on region by region. As I said a bit earlier, for me, actually, there is no really strong, homogeneous regional approaches. So the approach is cross-cutting.
But I understand India withdrew from many BITs, if I'm not wrong.
I think that what is really noticeable about India is the model, the BIT model that it has adopted a couple of years ago, which is also protective of public interest. Here, during the presentation, I took the example of the Belarus-India BIT, which is actually, if I'm not wrong, the first treaty adopted by India on the basis of its BIT model. And for instance, as I explained, with regard to indirect expropriation and regulatory measures, India considers that regulatory measures shall never be characterized as indirect expropriation, no matter whatever the impact on the investor. This is quite different from the approach adopted by the EU, for instance, or by the United States, which provide from the same principle, but which nevertheless provide for an exception when the impact of the measure is too severe on the investment in light of the purpose of the measure. So the Indian BIT model is very interesting and quite protective of public interest if you compare it to other treaties which have been recently adopted.
Thank you, Professor Radi. Another comment, I think, I would say it's a comment rather than a question, but you can discuss it if you wish, from Monsieur Boubacar Oumarou Yaye, certainly from Senegal, but I don't know, perhaps, or from the region, the sub-Saharan West Francophone African countries. So the main difficulty of the protection of investors, in my point of view, is when the host state is the one who breaches the contract and refuses to enforce an arbitral award. So I think the question here is when the state does not enforce an arbitral award rendered in a commercial arbitration. Mm-hmm. And so the investor would then escalate to investment arbitration against the host state.
Mm-hmm. And then the question also refers to breach of a contract by the host state.
So there is a breach of contract, and then the host state finds itself condemned in an arbitral award rendered in a commercial arbitration, I assume, mm-hmm. And then the investor escalates to investment arbitration. How can the investor deal with such difficulty? Usually the investor would initiate investment arbitration before exit. This happens a lot when a state does not enforce a commercial arbitration award. And then the investor escalates and go to exit and to start an investment arbitration, or to another institution that would be competent to administer investment arbitration. This is something that we have seen a lot.
Well, in exit proceedings, I wouldn't say so. And I'm just intrigued why our participant stresses that this is the most important issue in investor-state arbitration. Yeah, for me, based on arbitral practice, this is certainly not the most challenging and the most important issues from at least a quantitative point of view. So maybe the participant would like to clarify what is meant by this is the most important, most salient issue.
Thank you. Another question from Ms. Miguel Galendo. So she she's asking you about the CETA approach be a good way forward to delimit the content of the fair and equitable treatment, the FET provision. And she's asking that, she's saying, wouldn't this approach be open to interpretation as well?
So whether or not the CETA approach is the good one, well, I mean, in a way, it's a policy. It can be seen as a policy question, and so I cannot answer from a policy point of view. At the end of the day, whether you include a list or not is a policy choice which is made by states. Well, from a legal point of view, obviously providing for a list and limits the discretion of states when applying the FET provision. That being said, what remains is to determine exactly the scope of the substandards that are listed. So this is a step to circumscribe the exercise by arbitrators of their mandate, but there is still a margin when actually dealing with the substandards which are listed. But then in terms of treaty drafting, in a way, this is difficult for states when they draft the treaties to go much further. I mean, already we can see that treaties have become much more detailed, much more complex. I mean, if you take a treaty concluded 30 years ago, and if you compare it to treaties which have been adopted in the past years, I mean, the number of pages, the length of the provisions are really, really different. And in a way, we have to be cautious between being detailed doesn't necessarily mean that we are clearer. So the way to address the vagueness of treaty provision is not necessarily by being too far into entering into the details, because being too detailed can also lead to a lack of clarity. So this is my answer for Mr. Galendo.
Thank you very much for your answer. Mr. Daniel Il-Sanabawi, he is mentioning about your comments on the new Egyptian arbitration law for settling disputes related to investment. So either he means the Egyptian model BIT, and I'm not sure you dealt with in your book, and it's not public. It's not a public document. There is a new Egyptian model BIT that is being prepared by the GAFI in Egypt, but I'm not sure it's a public document. Or the recent attempts to amend the Egyptian arbitration law in general, but I think this is out of the scope of your book, which is focused on investment arbitration rather than commercial arbitration laws in the region.
Yes, it's outside the scope. Indeed.
But you haven't seen the Egyptian, the model investment, the model BIT that Egypt has prepared or drafted. Okay.
I look forward.
Another question is from Mr. Nabil Jauhari. So he is mentioning, okay, so given the confidentiality of arbitration, that the arbitral award is not subject to appeal, what are the current possible measures to avoid corruption, if any, in the arbitration process?
Well,
is it? Yeah, I have some ideas, but I will let you, of course, answer this question.
So, I mean, corruption, the fact that a member or members of the tribunal could have been corrupted. That's the question.
This can be one of the understanding of this question.
Yeah.
I thought this might be the intent of Mr. Nabil to ask about the corruption of the arbitrators or irregularity of the arbitration process itself, perhaps.
So yes, irregularity, yeah, and in general, annulment.
Yes, there is the judge, there is the pro-arbitration, the post-arbitral control or supervision that is done by the judges.
Yes, so annulment is not
whether setting aside proceedings or enforcement proceedings. And so this is the way. Regarding the corruption of arbitrators, I can give an example of the case in Egypt. In Egypt, if it is established that an arbitrator has been corrupt, so il a pris un pot de vin, so if there is a corruption of an arbitrator, the criminal sanction is the same applied to the corruption of a public official. So an arbitrator would be considered as a public official just for the purpose of applying the criminal sanction of corruption. Of course, the arbitrator is not a public official, but here for the purpose of this text, this criminal law text, he is dealt with as if he was a public official in order to be subject to the same sanction that would apply to a judge who is a public official, who is a civil servant. So if a judge is corrupt and if an arbitrator is corrupt within the Egyptian jurisdiction, the criminal sanction is the same.
Yeah. So post-award proceedings are the answer to those issues.
Yes. Now I haven't. So these are the questions that have been asked so far by the audience. In order not to stay too much long, I know that now our users are and everywhere are tired from webinars, although this webinar is very interesting. I will ask a question and we can try we would like to know your views on it. And it's about the near future, the reform of the ISDS regime. So you have mentioned the 2 or 3 approaches of this reform of the ISDS regime. You have also mentioned that you foresee that commercial arbitration would expand to fill in the vacuum that would be left if investment arbitration regresses or shrinks or disappears. But considering that we have the European Commission, so the European Union, that is pushing for abolishing investor-state arbitration and replacing it with multilateral or bilateral investment courts, whereby judges would be appointed to decide upon investment states disputes, versus the USA and other countries supporting another position, which is to maintain the investment arbitration, the ISDS regime, and reforming it and maintaining and reforming it. So can we say that we will, in the future, we will find a dual system, more or less, a dual system, where there will be an option for investment arbitration versus investment treaties providing for investment courts? Are we going to find the two regimes in the future?
Obviously, we're speaking about the future, so difficult.
What do you foresee? What do you foresee?
Well, again, obviously, I have no clear-cut answer on that, but this may happen indeed, that we end up with a system, a dispute settlement system, where different mechanisms exist, and depending on the treaties, there is an access to investor-state arbitration, there is an access to a permanent court, or there is an access to state-state arbitration. We may end up with such a system, for instance, I mean, if you look at a different field of international law, the law of the sea, disputes can be settled by the Tribunal for the Law of the Sea, or they can be settled under arbitration, or this can be the International Court of Justice. So different mechanisms are available. So all things being equal, that's in a strong possibility that we end up with a system where different mechanisms exist, and where the access to either mechanism depends on the treaty which is covering the investor.
And from your point of view, what should the countries of the South do in this respect? Because they are used to investment arbitration in a system where they do appoint their arbitrator, and now they are requested by the European Commission or by some European states, the state of the EU, to conclude new treaties providing for a multilateral court, and in which they will not be able to appoint or they have the same leverage in appointing the judges of this court. Is investment state arbitration a better option for the countries of the South?
Well, is it a better option? Then it depends what's the benchmark to appraise what is better than something else. So again, here, this is a policy choice to be made by states, and then a choice to be defended in the context of a treaty negotiation.
And will judges from the countries of the South sit in such multilateral investment courts?
Yeah, I think that no doubt. I mean, if a permanent court, a multilateral permanent court is constituted, there will be no doubt a representativeness. I think that there is no doubt that this will be the case, and that's obviously necessary. I mean, we cannot imagine having a permanent court, a multilateral permanent court, which would not be representative. I think that is simply not an option.
Thank you very much, Professor Radi, for this very interesting lecture. And also, I thank the audience for their active participation. They have asked many questions. At certain parts of your lecture, we reached more than 70 participants. And in addition to those who, because I have checked, those who were following us on Facebook. I don't know if Engineer Yahya has the figures of how many people were following us on Facebook.
It's about 10 persons, I think.
10 persons. So yeah. So So we can say 80 persons were following us today, which I think is a very decent number. So I thank Professor Radi very much, and I hope that you will participate in the future to the CIARB Egypt's activities and the centers, the CAI region centers activities in the future. I also thank the participants very much. They came from several regions of the world, and hope that you will those participants will also be with us in our next events. Thank you very much. Also, CRCICA team, Engineer Yahya, and all CRCICA team, who are supporting CIARB Egypt and providing their assistance to CIARB Egypt. Thank you very much. We will write something also on our newsletter about this event, and hope to see you soon, Professor Radi, unless you wish to say something to conclude.
Yeah, I just would like to again to thank you for the invitation, to thank your team for the preparation, and to thank the audience. As I said earlier, feel free to contact me if there is any topic that you would like us to discuss together. So thank you very much, and I look forward to participating to the activities of your center, Dr. Selim.
Thank you very much. Thank you. Thank you, Professor Radi. See you soon.
See you soon. Bye.
Bye-bye.